Did feminist superstar and potential arc-lich Ruth Bader Ginsburg actually kill the Equal Rights Amendment? The amendment that was supposed to bring equality under the Constitution to women across the United States and anywhere that its jurisdiction reaches? I don't know. Let's take a look and see what happened. I don't know. Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota, with just a quick legal hit for you. Below me is a picture of Ruth Bader Ginsburg, primarily known for eating the souls of children. I'm kidding. This is Ginsburg, who has survived many diseases while Donald Trump is still in office, and I hate to see how quickly she will degrade into a corpse the moment he is gone, but that's a separate topic. Here we go. Ruth Bader Ginsburg says deadline to ratify the Equal Rights Amendment has expired. I'd like it to start over. So some people, like if you read Vox.com, don't. But if you read Vox.com, they're framing this as Ginsburg killing the Equal Rights Amendment and stuff. And while she didn't actually do anything to officially kill the Equal Rights Amendment, we've gotten kind of an insight on her initial reaction to the Equal Rights Amendment's expiration clause and how it might be interpreted in the upcoming legal battle. Okay? If you're not aware, there's an attempt back in the late 70s to add the 28th, well, what would be now the 28th Amendment to the Constitution, although we didn't have 27 amendments back then. That doesn't matter. Add a new amendment to the Constitution, it would be the 28th Amendment. In 1977, they proposed this Equal Rights Amendment, which is very straightforward. And it simply says that women will not be, or that United States, under the Constitution, will not discriminate on the basis of sex in the application of law. Very straightforward. And even though we already have a 14th Amendment that pretty much covers this, we can take this as a cementing of sex-based discrimination being put under something we would call strict scrutiny. Okay? So we're getting into these deep inception levels of legal discussion here. But briefly, the levels of scrutiny are threefold, really. You have the rational basis, you have intermediate scrutiny, and then you have strict scrutiny. Strict scrutiny are things like implications on direct political speech, right? So any law that tries to restrict political speech is subject to what we call strict scrutiny. That's where the courts provide the highest bar for the government to overcome in passing those restrictions. It has to be related to a compelling government purpose, and it has to be narrowly tailored to be the least infringing on the right as possible. Okay. Sex-based discrimination, race-based discrimination falls under strict scrutiny currently, and sex-based discrimination actually falls typically under something what we call intermediate scrutiny, which is not as high of a barrier as strict scrutiny, although it's higher than rational basis. Rational basis is very easy. Think of it this way. If it's a rational basis test, the government is almost always going to win. If it's a strict scrutiny test, the government is almost always going to lose. And if it's an intermediate scrutiny test, it's really up in the air. It's 50-50. And the court is going to spend a lot of time balancing out the two different positions. Okay? So women have been pushing since the 70s for strict scrutiny under the Constitution. Should they get it? Should sex-based discrimination be a strict scrutiny question? That's actually a really big question, because there are differences between genders that are more pronounced than differences between races. I mean, for example, pregnancy is a very large one. So if the government wants to pass a law that favors pregnancy, right? It favors pregnant women. For example, in the United States, there's often a disparity between maternity and paternity leave. So if the government wants to pass a law granting some sort of extra right to women on the basis of pregnancy, well, then they only have to pass intermediate scrutiny. It only has to be related to a legitimate government purpose. That's intermediate scrutiny, rather than a compelling government purpose for strict scrutiny. So they're able to do that. Now, that's the inverse of what the goal of this is, right? The goal of this is to increase women's rights, but oftentimes the arguments for intermediate scrutiny can be used to actually further women's rights over men, rights that men would not otherwise get. And that's because the government doesn't have as high of a bar to favor women on things. Now, I'm not trying to balance this out and say that women haven't been subject to whatever. Don't read into it either way. I'm just saying that is one of the problems with with raising sex-based discrimination to the level of strict scrutiny versus intermediate scrutiny. It will have more profound impact on the, I guess, minority. Women aren't a minority, but that's the idea, right? Is that they're the lesser powered party. It will have an impact the opposite way on the lesser powered party in a way that race-based discrimination doesn't. All right, so there's issues. Is it proper? Maybe. I don't know, but it's a bigger legal discussion. However, back in the 70s, they had that legal discussion, getting back to it, and back in 1977, 2/3 of the House and 2/3 of the Senate passed this Equal Rights Amendment. And what they did was they gave a time window for when the states would have to ratify this thing to go ahead and add it to the Constitution. And that time window expired in 1982. And what they needed was 3/4 of the states to go ahead and ratify that. That would be 38 states. Okay? Well, Virginia, just a little bit ago, actually did become the 38th state to ratify this amendment to the Constitution. Sort of. We'll get to that. So they did it. Finally, we've got the 38. The only problem is, well, we're 18 years past the deadline. So there was a big question, and I've even talked about it a little bit on this channel, over whether or not this would actually be added to the Constitution. And the only thing we know is that there was going to be, and there still will be, a fight over whether or not that time limit is actually prohibitive to adding this to the Constitution. The question about it, the legal question about it, and why it might not be prohibitive is because, one, our Constitution doesn't say anything about the propriety of adding a time limit for the ratification of an amendment. For example, the 27th Amendment was ratified well over a century past its proposed addition. The states just hadn't ratified it. Some guy went out and petitioned a bunch of states and they moved on it, but there was no time limit included. The second part of the problem is that the time limit that was included is in the preamble to the constitutional text. It's not in the text itself. Now, why is it not in the text itself? Because it doesn't really make sense to have it in the text itself, so they put it in the preamble. The question, though, is that preamble operative? Is that legally operative? We don't know. There's not a lot of precedent for it, other than the fact that other constitutional amendments that have been proposed with time limits that were not met have failed. That's about all we've got. But that doesn't mean that they all have to fail. So there is an upcoming legal fight. I believe at least 3 or 4 states' attorneys general have filed lawsuits suing to add the Equal Rights Amendment to the Constitution as the 28th Amendment, as its ratification requirements under the Constitution have been met. So there's going to be a fight no matter what. And of course, this will be framed by the media as conservative versus liberal, because that's how they understand the court, because they don't really understand the court. Now, while it may shake out that way, that's not actually that's not the safest bet in the world. When you have a constitutional originalist, they may not accept the idea of a preamble being prohibitive of the constitutional requirements. For example, I don't know how they're going to vote, but if they believe that the constitutional requirement is merely 2/3 of the House, 2/3 of the Senate, and then 3/4 of the state ratifying it, they may say that the preamble is merely a guideline or suggestion and is not legally operative under the Constitution, and therefore it can be added. It's not really a liberal versus conservative issue, although it's much better for the media, right, to come out and frame this. And this is why they're so confused by Ginsburg. They don't know what to make of this, and they're actually a little bit terrified. The problem is they want this to be left versus right, conservative versus liberal, meninist versus femininist, or whatever. That's what they want it to be because it's an easier narrative to sell when you're trying to get clicks. But we don't know how it'll actually shake out, and there would be a lot of analysis to try and guess. Plus, we haven't even seen any of the actual arguments coming out at this point, for or against. That being said, we've got this issue, and Ginsburg has made a couple comments on it. I would like to see a new beginning. I'd like it to start over. Now, there are ideological reasons that she might want it to start over, right? She might want to show a popular support for feminism now that didn't exist. They failed to meet a 5-year window of ratification, right? That's a blow. That's a moral blow to the movement. So if you're a purist in the movement, you would want to show that today we're better than we were from 1977 and 1982. Again, better being a relative term based on the ideology at stake. Okay, I'm not making a value judgment. I don't care. If we have strict scrutiny for gender-based discrimination, cool. If we have intermediate scrutiny, cool. That's what we've got. We're going to figure it out. We've been figuring it out for a while now. And the court may do this on its own anyway. There's no specific reason that they need to stick with intermediate scrutiny. A Supreme Court could actually determine with the right case that this should be subject to strict scrutiny and that the subject of intermediate scrutiny was an improper imposition in the first place. They can do that. I don't know that they will. You'd need the right case and the right situation and all of that. But that being said, there are reasons that Ginsburg would want to do this. For the ideology of the feminist movement. So she's not like losing her status as a feminist icon or anything like that here. People can do that. But she responded to a question from the moderator of the event, Judge M. Margaret McKeown of the Ninth Circuit Court of Appeals, who asked whether there would ever be an equal rights amendment on the federal level. It would ban discrimination on the basis of sex and guarantee equality for women under the Constitution. I mean, that sounds great, but it would actually just subject it to a higher level of scrutiny than we currently have, and just ask Black people if they feel equal under the Constitution. Many of them will tell you no. Many of the people supporting this amendment would tell you no. So but that's a separate question. So her comments seem to throw cold water on a recent effort by Virginia. Blah blah blah. Nodding in response to the question about the dispute, Ginsburg said there's too much controversy about latecomers, and she added that the Virginia's move came long after the deadline passed. So she's given us an indication of how she might initially frame this. It doesn't mean she can't be persuaded, and it doesn't mean she will vote this way ultimately when we get down to it. But wouldn't it be cleaner, and Ginsburg's sending a clear signal here, wouldn't it be cleaner if the House and Senate got together, repassed this, and the states went ahead and ratified it? The other problem is Virginia is the 38th state to ratify it, but in the intervening years, 5 of the states who initially ratified the constitutional amendment have withdrawn their ratification, and Ginsburg points out, blah, blah, blah. I don't know if it's in this article or not. Oh, it's not. Good. Good job. Great job, CNN. Anyway, it's not in this article, but 5 states have actually withdrawn their ratification, and Ginsburg's response to that was something along the line, well, maybe it wasn't Ginsburg's. Now I don't even know. But the response to that is, if we're going to allow a late ratification, how would we similarly disallow people to withdraw the ratification that they had given before it's officially added to the Constitution? If they've changed their minds, Virginia changed its mind. Now these states have changed their minds back. So do we get to count that as 38 states? I don't know. There are too many questions about it, is what Ginsburg is saying, and she would like to see those questions resolved by merely the passage of a new amendment, a resurgence of the pro-feminism sort of thing, and that makes a lot of sense. So did she kill it, though? Is it dead? Well, no, it's not dead. We still have lots of arguments. Ginsburg could still vote to ratify it. Maybe she'll be persuaded by her fellow justices. Don't know. But she's given us an indication of how she frames the case at this point in time. But we haven't seen how that case will actually get to the Supreme Court yet. So we still have to stay tuned. This is still a multi-year legal battle. And Ginsburg may not even live to see it, frankly. I mean, not to be rude, but she is already dead. So she definitely is at risk of not making it to the hearing. As long as Trump's in office, she'll be there. All right, guys. Thanks for hanging out. Thanks for watching. Hope these quick hits are something you like. If they are, like, share, subscribe, all that good stuff. Talk to you soon. Have a good day. Peace. Peace.